We are slated to start at 10:30 this morning. Just as I had mentioned before, today we are going to be following most of the modalities of the court. So expect us to, ask you to all rise when the bench is coming in. Please put your phones on speaker mode and avoid interruptions. Also, once again, this session is going to be filmed and live streamed on our YouTube page, so please keep that in mind. My name is Kei Kanyali Mwiki, and I'm a program officer at Equality Now. And I would just like to acknowledge all of you and thank you for making it today. In the audience, we have Carol Osero Agengo, who is the regional representative for Africa at Help Age International, which is a human rights organization that we work very closely with. And she's also a member of the SOAWR coalition. Thank you for being in the audience, Carol. We'd also like to recognize the presence of Dr. Maxime Huinato, who's the UN Women Regional Director for East and Southern Africa, Madame Zebib Kavuma, who's the UN Women Deputy Regional Director for East and Southern Africa, and Madame Sunita Kaminya, who's the UN Regional Specialist ending The Honorable African Court on Human and People's Rights is now in session.
Good morning, councils. Good morning, ladies and gentlemen from the public gallery. Very good morning to the press. And thank you very much for your logistical and technical assistance to ensure that our hearing is live streamed online, of course. I should also greet people who are following us online, especially people who are following us from the beautiful Republic of Akunda. As you know, I just want to welcome you to this public hearing of the African Court of Human and People's Rights, exceptionally sitting from the Republic of Akunda. May I request the registrar to call the case, please?
Case 001 of 2023, GE 3003 versus GE 1909. Please alert this honorable court your time allocation before proceeding.
Was not on. I apologize for that. So as I said, this case will be heard before a bench of 5 judges who will introduce themselves, beginning by the far left.
Good morning, everyone. Orasa Jolohung. I'm head of the legal division of the African Court and extraordinary lecturer at University of Pretoria.
Good morning, everyone. My name is Tike Mwambipile. I'm the Executive Director of the Tanzania Women Lawyers Association.
Very good morning again. My name is Pacific Maniakiza. I'm a professor of law at University of Ottawa, Ontario in Canada. And formerly I was a member of the African Commission on Human and People's Rights.
I'm Lillian Tibate Maichiri Kubenza. I'm Justice of the Supreme Court in Uganda. I'm also a non-resident judge on the Court of Appeal in the Seychelles. I also teach on the JIFA, that is Judicial Institute for Africa, based at University of Cape Town in South Africa.
I am Christine Konge, the Executive Director of Katiba Institute.
Thank you very much, dear colleagues. May I now request the counsels of both teams to introduce themselves, starting by the applicant. Please do also let us know how you allocate the time among yourselves.
May it please the court, Mr. President and honorable judges of the court, my name is Claudio Junior Faro, lead counsel for the applicant in the matter between Challenge and Change Association versus the state of Akunda, and I appear together with my co-counsel, Miss Nadia Mutisi, and we are team GE 3003. I will address you, Mr. President and honorable judges of the court, in respect to the procedural issues which are jurisdiction and admissibility, for 13 minutes. And my co-counsel, Ms. Nadia Mtisi, will address you in respect to the substantive issues for 14 minutes, and we respectively reserve 3 minutes for our rebuttal.
Thank you very much, lead counsel. The counsel for the respondent state.
Your Excellencies, I am Nwankwo Blessing, lead agent for the respondent in the case between the Challenge and Change Association, CACA, and the state of Akunda. Appearing with me is my learned friend and co-agent, Akinyemi Akinwumi, and together our humble appearance is for the respondent in this case. I will be addressing this court on the issues of jurisdiction, admissibility, as well as substantive issue 1 for 14 minutes, while my learned friend and co-agent will be addressing the court on the merits of issues 2, 3, and 4 for 12 minutes. And we have left 4 minutes for our SOAWR rebuttals. Most grateful, Your Excellencies.
Thank you very much, lead counsel. Now I invite the applicant to present their case. As you know, you have 30 minutes, and be aware that judges may interrupt you at any time. Thank you very much.
Mr. President and honorable judges of the court, we respectively invite this court to adjudge that the state of Akunda has failed to prosecute and investigate cases of sexual and online gender-based violence, and that they have also failed to put in place measures which would guarantee the political participation of women in Akunda, and that this constitutes a violation of obligations emanating from treaties and conventions to which the state of Akunda is a party. If the court is to find favor with our argument, we pray it finds that the applicant's case is founded, and consequently order the respondent state to pay compensation to the victims of the violations, and also put in place effective measures which would guarantee the political participation of women and also guarantee the sexual rights of women and girls within the state of Akunda.
Now that the court knows why you are here, what is your understanding of Rule 48? Rule 48 of the protocol establishing the African Court. Just discuss that which is relevant today.
Most indebted, honorable judge. Honorable Judge, Rule 48 of the protocol establishing this court, in fact, the whole rules of the court, they provide for the rules of procedure in the functioning of this court in the vindication of human rights in Africa. And I believe that as far as our case is concerned, we base the arguments that we are making on Rule 49 of the African Court Rules of 2020, which mandates this court to conduct a preliminary investigation into its jurisdiction and admissibility before it seizes itself with the merits of any case.
So what is the importance of that rule to your presence in court today? Has the state of Akunda made a declaration that they are willing to appear before the court, that the African court has jurisdiction over them?
Most indebted, Madam Honorable Judge, we acknowledge the fact that according to the determination which was made by this court in the case of Mutilika versus Tanzania, application number 9 of 2011, one of the dates which are important as far as the exercise of this court's temporal jurisdiction is the date that the state concerned deposited a declaration pursuant to Article 34, Sub-Article 6 of the African Court Protocol, confirming this court's jurisdiction. In that regard, we also acknowledge that from paragraph 6 of the facts, it is quite clear that although the respondent state has ratified the African Court Protocol, they have not yet deposited the declaration which confirms this court's jurisdiction. But we invite this court to consider a reasoning which was made by the Honorable Judge Fata Ogugos in the case of Yogogo Mboye versus Senegal, application number 1 of 2008, whereby the court, in developing upon the principle of forum prorogatum, ascertained that if parties have behaved in a manner which shows that they are submitting themselves to the jurisdiction of the court, then even if the court would originally not have jurisdiction in that particular case, it would thus exercise its jurisdiction. So in this particular case, the parties are before the court, the respondent state is before the court, they have filed pleadings before the court, and they will also make submissions on the merits in this particular case. And the court has also used the resources for the case to reach where it is at the moment. So invite the court to consider that reasoning and exercise its jurisdiction, even though the state of Akunda has not deposited that declaration.
Counsel, to what extent do you believe that the dissenting opinion of a judge would override the majority judgment? And here you also raising the issue of forum prorogatum as a way of attempting to escape the provisions for a declaration to be made prior to a state being brought before this court. So now, if you're using the concept of forum prorogatum to try and attempt and reach this court, why would you then use as your main basis the dissenting opinion of a judge who does not represent the views of the court, who does not represent the views of the majority, and therefore try to attempt to ground your case on this basis? Again, while answering this question, I want to reset your submissions in the sense that you initially submitted to this court that you wanted to address the court on some main issues, which I believe were issues concerning merit. And my colleague had tried to bring you back to the scene by drawing your attention to the fact that you should have rather started by pleading on the procedural issues, mainly jurisdiction and admissibility of the case. So while you answer the issue on forum prorogatum, I would want you to bring us back to just a reset of the submissions by addressing the issue on jurisdiction so that we can then proceed from there.
Most indebted Honorable Judge. Honorable Judge, the point that we made was for the court to consider the separate opinion of the Honorable Judge Fata Ogugos. But even if the court is not persuaded by that separate opinion, it is still the applicant's submission that this court has discretion to exercise its jurisdiction on the basis of Rule 29, Sub-Rule 3 of the African Court Rules of 2020. And considering the nature of the violations which have been violated in this particular case, this court ought be persuaded to exercise its jurisdiction in this particular regard. Mr. President and honorable judges of the court, this case pertains vulnerable women and girls within the state of Akunda who are being sexually abused, who are also being politically excluded, and therefore it is the applicant's submission that this court ought be persuaded to exercise its discretion in exercising its jurisdiction over this particular matter pursuant to the rules of the court.
So, Counsel, you are basically saying that the dissenting opinion can be a source of law applicable before this court. I'm pretty sure you are aware of the sources of international law. Under which category can you put that kind of source of law?
Most indebted, Mr. President. Mr. President, what we did with the separate opinion, since Honorable Judge Fata Ogugos was sitting and determining that particular case, although his opinion was a separate opinion, we are inviting the court to consider the reasoning that he made. But as we said, even if the court is to consider otherwise, we then argue that it must exercise its jurisdiction on the basis of Rule 29 sub Rule 3, which gives it discretion in that regard.
Would you call that judicial activism?
Most indebted Honorable Judge, we can call it that way.
What is judicial activism? Because I don't want you to say we can call it. I want to be sure that you know what it is.
Most indebted Honorable Judge, judicial activism, this is where judges, wherever in instances, even when there is a gap within the law, they are given an opportunity to make determinations we should provide for that gap, or make determinations we should give them the authority that legislatures originally have. And although they are not legislatures, they would come in the shoes of legislatures and make determinations. Rather, we should build on the law, and this is an opportunity for this court to do judicial activism and create precedents in this regard.
Yeah. Good and fine, no, and I don't think you are arguing on the basis of judicial activism here. I think your case, you've made it in respect of the declaration. Basically, you are saying this court should exercise jurisdiction ratione personae. That is in respect of that respondent state based on forum prerogatum. And you have said that you are arguing so because, one, the application was served on the respondent state. Two, the respondent state filed pleadings. Three, the respondent state is appearing before this court, and therefore, there's no way the respondent state can argue that they didn't file the declaration, and therefore, they are not under the jurisdiction of this court, if I understood you well. Now, where I plead with the Honorable President is to request that you take us back to the beginning of the submissions. Because you started addressing the court on issues of merit, and then you were called back to say, go and deal with some issues concerning jurisdiction and admissibility. It would be proper, in my view, if we do it the way it should be done, address us on jurisdiction, address us on admissibility, and then you go to the merit of the matter, please.
I stand guided, Honorable Judge. Honorable Judge, as far as material jurisdiction is concerned, the respondents might argue that they have made reservations to Article 9, Sub-Article 2, and Article 14, Sub-Article 2 of the Maputo Protocol, and therefore these articles do not apply in this particular matter. But it is the applicant's submission in this regard that the reservations made to the Maputo Protocol are invalid on the basis that they defy the object and purpose of the Maputo Protocol, and therefore on the basis of Article 19, Sub-Article C of the Vienna Convention on the Law of Treaties, they should be declared invalid. We understand that the respondent in this matter have argued that they have no sufficient resources in order to provide a guarantee for sexual and political rights for women and girls within the state of Akunda. But if I may draw the court's attention to paragraph 3 of the facts, it is quite clear that the state of Akunda prioritizes technological infrastructure for economic reasons. And in paragraph 10 of the facts, the president asserted that the reason why they were engaging in technological infrastructure was for economic reasons. And this is the same state which is claiming that it does not have the resources to guarantee the fundamental rights and freedoms of women and girls within the state of Akunda. And therefore, the preamble of the Maputo Protocol mandates member states to give due regard to the rights of women and girls in all undertaking, and to therefore prioritize technological infrastructure to the rights of women and girls would definitely fall of the Maputo Protocol, and hence the reservations should be rendered invalid. Moving on to address the court on admissibility, it is the applicant's case that this case is suitable for adjudication before this court, since the applicant has complied with the admissibility criteria provided for under Article 56 of the African Charter, as read together with the Rule 50 of the African Court Rules of 2020. The respondents might argue that the applicant has not exhausted domestic remedies, but it is the applicant's submission in that regard that the domestic remedies within the state of Akunda are ineffective and insufficient, hence justifying the applicants approaching this court. If I may draw the court's attention to the case of Jawara versus the Gambia, which was determined by the African Commission, Communication number 147 of 1995, whereby the court asserted that in determining effectiveness, the court ought to give due regard to the fact of whether the remedies available at local level are capable of addressing the concerns that have been raised. In sufficiency, the court ought to consider the prospects of success in a particular local remedy which is provided for under local level. I understand that my time is up. If the court may grant me maybe 2 minutes to round up my...
Granted.
Most indebted, Mr. President. Mr. President, as far as the prospects of success are concerned, it is quite clear that according to paragraph 21 of the facts, the Constitutional Court within the state of Akunda had made a declaration that the courts in Akunda have no jurisdiction in respect to violations emanating from online gender-based violence. In that particular regard, it means that all the victims of online gender-based violence within the state of Akunda have no remedy before the court in Akunda, and they have no prospects of success since the Constitutional Court has already made a declaration in that regard. And as far as the effectiveness of the remedies is concerned, we also take note of the fact that the Constitutional Court within the state of Akunda rested the fate of vulnerable women and girls within Akunda who were being sexually abused and politically excluded in the hands of a Gender Equality Commission, which according to the norms or the legal norms, commissions can only issue recommendatory decisions which are not binding upon the respondent state, and hence they can't be regarded effective. In saying this, I invite the court to consider the reasoning which was adopted by the United Nations Human Rights Committee in the case of DR versus Australia, whereby the committee rather asserted that decisions from commissions are merely recommendatory and not binding, and therefore they do not bind the state concerned in any particular matter. And litigants are therefore justified to not exhaust those remedies in pursuit of those remedies which would grant them an effective remedy. And lastly, I would also want to draw the court's attention to the Maputo Protocol, which expressly provides that in giving effect to the provisions of the Maputo Protocol, state parties ought to make sure that there is effective remedy in that regard, and hence the applicant's case is admissible on the basis that we have adhered to the admissibility criteria.
Counsel, yeah, I've been listening to you. Now the issue is basically you are pleading that this court should consider that domestic remedies did exist, but were not effective. Now, what do you say of the option that existed for you guys to have seized the Supreme Court of Appeal, which would then consider cases on appeal of decisions rendered by the Constitutional Court? So now you have not attempted to seize the Supreme Court of Appeal at all, and now you do say that the remedies are not effective. That's number one. Number two, do you consider that the mere fact for the Constitutional Court to have arrived at the decision to the effect that this matter was not within their jurisdiction, would you consider that to be a denial of justice? Because the outcome of you attempting to use some of the domestic remedies, the outcome would matter less. The process would matter more. Now, you are not requested to show this court whether you have won your case before the Constitutional Court or not, but merely to prove that you have attempted to use the Constitutional Court and there's an outcome. And there was a ruling of the Constitutional Court to the effect that the court didn't have jurisdiction. So there is that issue, and then there's the issue of you having not attempted at all to use the remedy of the Supreme Court of Appeal. So what do you have to say about that?
Most indebted Honorable Judge. Honorable Judge, responding to the first question that the applicants did not approach the Supreme Court for redress, may I draw the court's attention to paragraph 7 of the facts, which expressly provide that you can only approach the Supreme Court if you are granted leave of the court by the Constitutional Court. And this is the same Constitutional Court that said that the courts within the state of Akunda do not have jurisdiction to adjudicate over...
But counsel, the leave is supposed to grant you access to the Supreme Court of Appeal. So you cannot amalgamate the issue of what was the outcome of the case before the Constitutional Court with that of the proceedings before the Supreme Court of Appeal. So basically, you are saying, I am not going to exhaust the remedy of the Supreme Court of Appeal because the leave is supposed to be granted by the Constitutional Court. It doesn't make sense, because then you do your processes of obtaining leave from the Constitutional Court for the purposes of seizing the Supreme Court of Appeal.
Most indebted Honorable Judge, adding on to the response that I was making, I would also want to draw the court's attention to paragraph 22 of the facts, which shows that the applicant's decision to bypass the Supreme Court was also substantiated on the basis of the fact that the general elections were nearing. And since our case pertains the infringement of political rights, which would want to guarantee that women and girls within the state of Akunda are granted or their right to political participation is guaranteed, we were justified in taking a remedy which would rather be effective or efficient in that particular manner. And
Council, wrap up your arguments so that we hear the case on the merits.
Most indebted, Mr. President, I would just want to conclude by responding to the second question which was given by the Honorable Judge in respect to the fact that did the Constitutional Court deny justice to the applicants on the basis that they said the courts in Akunda did not have jurisdiction to adjudicate over online gender-based violence. We would want to respond saying that the state of Akunda is mandated under the obligations emanating from treaties and conventions to which they are a party to grant that effective remedy. And when the courts, which are supposed to be there to vindicate these rights, ascertained that they cannot interfere in a clear violation of cases, in a clear violation of rights, these women and girls were vulnerable and they were being sexually abused and politically excluded. We therefore argue that there was denial of justice. Unless I am of further assistance to the court, I may defer proceedings to my co-counsel.
Thank you very much.
Honorable Judge President, Your Excellencies, and may it please the court. My name is Nadia Mutisi. I am the second counsel for the applicant in the matter, Challenge and Change Association versus the State of Akunda. Honorable Judge President, Your Excellencies, the women and girls within the state of Akunda have been facing gender-based violence, online coordinated harassment, human trafficking, and other forms of gender-based violence. Within my submissions, I will address this honorable court with respect to the merits of the claims, starting firstly with claim number 1, as it pertains to the fact that the state of Akunda failed to ensure investigations and prosecutions pertaining to gender-based violence. Secondly, I will address this honorable court with respect to the violation of the political rights of the women within the state of Akunda. It is the applicant's submission that the respondent has violated Article 2, Sub-Article 1B of the Maputo Protocol, which refers to the enactment and effective implementation of laws within the state. Article 2, Sub-Article 2 of the Maputo Protocol, which refers to the resocialization obligations that fall upon a state. Article 3, Sub-Article 1 of the Maputo Protocol, which speaks into the right to human dignity. Article 3, Sub-Article 4 of the Maputo Protocol, which also speaks into initiating effective legislation. And finally, Article 18, Sub-Article 3 of the Banjul Charter. These particular provisions relate specifically to the first claim. Your Excellencies, Recommendation number 35, as dispensed by the Special Rapporteur on the elimination of violence against women, recognize that opinion jurists and state practice have essentially established that the prohibition of gender-based violence has become a norm of international law, meaning that it has acquired a jus cogens characteristics and that it ought not to be derogated by any state. General Recommendation number 19 of the Committee on the Elimination of Discrimination Against Women essentially stated that gender-based violence is a form of discrimination. The provisions which I have cited speak into discrimination, meaning that they can adequately canvass issues of gender-based violence. Now, we do understand that the actions that we come to argue about today are not necessarily the actions of the state, but the actions of private actors. Under the due diligence obligation, which was first canvassed in the Inter-American Court case of Velasquez-Rodriguez versus the state of Honduras, it was stated that states can be held liable for the actions of private entities, especially where states fail to act with due diligence. What does this mean? That states are expected to prevent the violation of human rights, they're expected to investigate the violation of these particular human rights, and finally, they're expected to prosecute the violation of these human rights. The due diligence test has also been canvassed before the European Court of Human Rights, in the case of Opus versus Turkey, and before this very court, in the case of Zongo and others versus Burkina Faso. I refer to a report made in 2006 by the Special Rapporteur on the Elimination of Violence Against Women, where it was stated once again that states have an obligation to ensure due diligence and that this is a rule of customary international law. Applicant acknowledges the fact that the respondent has put in place a plethora of laws and mechanisms to ensure the rights of women within the state of Akunda. However, it is the applicant's contestation that these particular rules, policies, and mechanisms speak into a de jure realization of rights and not a de facto realization of rights. What we mean to say is that there is no effective realization of rights within the state of Akunda. We therefore request the court to take into consideration the women and girls of the Medu region who day after day after day face continual violence, face human trafficking, face sexual violence owing to the fact that they seek and search for a basic human right, the right to water. Consider the women political candidates within the state of Akunda who, according to paragraph 17 of the facts, have been facing threats of violence, insults, coordinated harassment, and the public disclosure of their private information, despite the laws and policies that have been put into place by the respondent. With that being stated, it is the applicant's admission that there is no practical and effective realization of these rights. Article 2, sub-article 1b of the Maputo Protocol requires a practical and effective implementation of laws. There are a number of cases as well that canvass this particular issue. For instance, in the case of Legal Resource Foundation versus Zambia, appearing into Article 1 of the Banjul Charter essentially established that states ought not to merely recognize rights, states must ensure that rights are effective. In the case of Goek versus Austria, it was stated that states must ensure that rights can be practically implemented. In the case of VK versus Bulgaria, it was also stated that state entities such as the police, as well as in this case, Article 199 of the Supreme Law of the Land, which establishes the Gender Equality Commission. So entities such as the Gender Equality Commission are also required to work in tandem with the state in order to ensure that there is a practical realization of rights. Throughout the entire hypothetical case, there is no single mention of police officers or police enforcement, which essentially shows that there is zero practical enforcement of these particular rights.
So let me take you back. There's something you said about the gender violence, the norm prohibiting gender violence, and you stated that the prohibition of gender violence is now a norm of international customary law. And you directed the court to the one of the pronouncement of the international. Exactly. So what's the value of those pronouncements from either the special rapporteur or the international committee on the elimination of the,
Indeed. We submit that the recommendations that we have cited, being recommendation number 35, recommendation number 19, as well as the reports that have been presented by the Special Rapporteur, most of these entities emanate from the United Nations-based organizations which have dispensed other treaties such as the ICCPR, ICESCR, the United Nations Declaration on Human Rights. We submit that these would have a persuasive effect upon the court. These are soft law documents, and therefore they are highly persuasive to the court. They have also been taken into consideration by a number of committees and tribunal, specifically the Committee on the Elimination of All Forms of Discrimination Against Women. Therefore, our submission is simply that it would be highly persuasive before this honorable court.
Counsel, you raised the issue of due diligence. Now, here we are in a really single occurrence case. We have had this single case, one case of violation, And you tend to construe this single case as a prolonged or sustained or achieving trend case. I have an issue with this because the definition of due diligence would rather be a trend that begins to be consistent. And therefore, you're talking about quantity, you're talking about numbers, and you're also talking about gravity. So how do you locate the current circumstances in the overall framework of defining due diligence? Why would you want to define due diligence on the basis of a single and isolated case here? So basically, are you saying if there is a single occurrence, a single event of breach of human rights, that would automatically constitute a trend of lack of due diligence on the part of the respondent state?
Indeed, Your Excellency, in responding to that question, we do agree that the concept of due diligence, as was stated in the case of Maria da Pena, also known as the Fernandez case, has an aspect of there having to be a pattern that ought to be established. Where we, however, seem to contestate the claims that you have made is that it is one case. It is not one case. These are the cases of many women within the state of Akunda, particularly with regard to the Lolon community and the women within the Medu region. They began to face these violations in 2020. The case that is then taken to the courts only obtains in 2022. The cases that begin to happen to the women political candidates within the state of Akunda happen in 2021. This essentially means that there have been continuous violations of these particular human rights. There has been a pattern that has been shown, and we're going to prove that particular pattern. Since 2020, we have been able to establish that there have been violations. The state of Akunda only then engages the international community when the international community then threatens to impose sanctions upon the state. That is the only time that the state of Akunda finds it convenient for them to be able to then address these particular issues. With that regard, we state that they have failed to meet the due diligence obligations.
I have one last concern on the issue of, because I believe this is important, on how one would connect international humanitarian law and human rights law in defining the scope of protection of women's rights. Here, you raise the issue of customary international law. To what extent do you believe that you can draw only from international human rights law to support a case of either due diligence or breach of women's rights or protection of women's rights, not using at all international humanitarian law? Because you also raise case law from the Inter-American Court of Human Rights, which is a human rights court. And I haven't heard you say anything about the whole lot of legal norms that exist in the field of international humanitarian law.
All right. Thank you for that question, Your Excellency. In response to your question, it is our firm belief that international humanitarian law mainly obtains or is mainly utilized in cases of war situations. However, there are certain principles that occur within international humanitarian law that we may want to refer to, for instance, the principle of proportionality, which we may find cuts across the board, although in different circumstances and can be applied differently. However, we do not borrow from that particular field of law owing to the fact that it is applied in times of war. There are also a set of treaties and conventions that relate specifically to those that the state in question is not a party to, or it's not canvassed within the fact matrix. If the court is pleased, I would like to address the court with regards to political participation. Your Excellencies, we submit once again that there is legislation promoting political participation within the state of Akunda. However, the right to political participation once again is not practically realized. We understand from paragraph 8 of the facts that there is a progressive constitution, that there is a Parties Act which provides for quota systems to be implemented. However, despite this, only 21% of Akunda's parliament consists of women. There are only 11 governors out of 55 prefectures that are representative of women. Not only this, but Akunda, in instituting the internet shutdown, also then limited the political rights of these particular women. We refer to the ECOWAS court case of Amnesty International versus the Togolese Republic, whereby it was stated that while there is no stricto sensu right to the internet, freedoms, such as the freedom of expression, are then undercut when the internet is shut down. We submit that these particular rights, the political rights of women, were violated, placing reliance on the case of the African Commission case of Amnesty International and others versus Sudan, whereby it was stated that freedom of expression is a fundamental human right that is essential to an individual's personal development, political consciousness, and participation in the public affairs of a country. Now, for one to be able to successfully limit the right, there are three things that ought to be considered. Number one, it must be provided for by a law. Number two, it must be necessary for you to then implement that particular restriction. And number three, it must also be proven that it was proportional, that there was a legitimate aim that was being sought. The applicant's contestation with the institution of that particular internet shutdown is that there was no legitimate aim. We understand that the internet shutdown obtains owing to an uproar that occurs after Order number 24 has been instituted. But Your Excellencies, a look at the facts will show you that Order number 24 was instituted in November of 2021. Protests only ended in around February of 2022. But then the internet shutdown is instituted in April of 2022. There has been sufficient time for the situation to be able to abate. Therefore, the reliance and the justification provided by the respondent to state that it was a matter of national security is a farce, and it is not true. We therefore submit that there was no legitimate aim whatsoever for there to have been an internet shutdown. Freedoms such as the freedom of expression have been canvassed by this court in the case of Umuhoza versus Rwanda, and it has been stated that these are freedoms that are crucial to a democratic society. With that being stated, it is therefore the applicant's submission that the state of Akunda has violated the rights of women pertaining to gender-based violence, has violated and failed to ensure the political rights of women. Our prayer...
You go on. I do believe that the state of Ankunda recognizes these rights. The shutdown was not focused or directed against women, exclusively directed against women. So can you convince this court that what happened was tantamount to violation of the rights of women rather than violation of the rights of the citizens of Ankunda?
All right. Thank you very much for that question, Your Excellency. We submit the idea of the internet shutdown pertaining to the political rights of women. From the facts, what we understand is that the Women Gender Party is mostly operating online, owing to the fact that they have been facing different forms of gender-based violence, including physical violence. What this means is that the Women Gender Party is the main party that is operating online. Towards elections, the Women Gender Party is then going to be specifically affected by the internet shutdown because it is a party that is full of women, or comprises about 70 women within that particular party who are running, and these women are using the internet for them to be able to run their campaign. It therefore becomes a specified...
Yeah, can the state be accountable on the online violations? How?
Also, there's a factual issue here, because I read the fact thoroughly. So now there's an issue here with fact. Months elapses between the shutdown and the elections. Okay, about a couple of months, 3, 4, 5 or thereabout. So how do you explain the fact that now you are saying this impacted directly the political party? That's number one. Number two, what do you see of the issue of balancing right? Because here, there are issues of national security that arise. And as a state, there are competing obligations being born from ratifying a treaty. And now you do have about 25 different obligations in a treaty. And you are requesting a state to meet these obligations at par. Basically, you are telling the state, the same time we want you to be focusing on dealing with women's rights fully, we also want you to give us security 100%. So here you are not addressing the issue of the respondent state having to meet their duty of at the same time ensuring that women's rights are met, but also that national security demands are met. How do you do the right balancing here?
Most obliged, Your Excellencies. I will respond to
All right. Added to the question by His Excellency, also respond to the temporary nature of the order. And
All
I think
right.
it is tied in very well to what His Excellency asked.
All right. Most indebted, Your Excellencies. In response to the first question, can the state be held responsible for these things that are happening online? When we were beginning our argument, we canvassed the issue of resocialization. We submit that these particular online violations only occur because of misogyny, patriarchy, and sexism that exists within the state. The state has an obligation under Article 2, Sub-Article 2 of the Maputo Protocol to ensure resocialization. Resolution 522 of the African Commission, which speaks into digital violence, also says that states must ensure awareness raising to ensure that people are educated about gender equality. The failure of the state to ensure resocialization is one of the main things that then causes these online and digital-based violence claims. With that being stated, yes, the state can be held responsible because a crucial element that can prevent this has not been taken into consideration and upheld by the state. With respect to the other questions, pertaining to the elections, we refer to resolution number 174 of the African Commission, which essentially states that in times of elections, states must ensure that other political parties have access to the media and access to the means of communication. With that being stated, by cutting off the internet, this is an important aspect of them being able to campaign, goes against the fundamentals of resolution number 174, and therefore the state can be held liable. While we do consider the fact that there is a bit of a period between the time that the internet shutdown occurs and the time that the elections are going to obtain, we cannot undermine the ability of a state of a party to be able to hold, to be able to effectively be able to campaign, particularly where there are significant barriers against you. First of all, you're women, receiving calls from multiple political leaders that are threatening you. There are so many factors that are then going to lead to the Women Gender Party being unable to effectively participate. We refer to the case of Yatama versus Nicaragua, which is an inter-American court case, and it was stated that states must be able to ensure and to be able to actually help these particular political parties, especially of indigenous communities, but in this case, we're representing a marginalized community, being women. So states actually have an obligation to help these particular women to be able to participate within the elections. The other question was on the issue of balancing of rights. We do not believe that this was an issue of national security. While rights must be balanced, and this is canvassed under Article 27, Sub-Article 2 of the Banjul Charter, in this particular case, it is a farce that this was a matter of national security. I believe I'm missing the last question that was asked by Her Excellency.
That is fine, Council, just go.
All right, if the court is pleased, if I may have just 1 minute to canvass our prayer before this honorable court.
Good.
Your Excellencies, our prayer before this honorable court, that the court would be able to find favor with our case, that they would find that this matter is admissible before this court, and that the court has adequate jurisdiction over this case. We also pray that the court may find that the respondent failed to fulfill due diligence obligations with respect to gender-based violence, that the state violated the political rights of women and girls within the state of Akunda, and finally, to order the respondent to put in place measures that ensure an effective realization of the rights of women, including an order to perform resocialization within the state of Akunda. If the court is pleased, I beg to defer proceedings to the court.
Thank you very much, Counsel. Now we're going to hear the arguments from the respondent state. Go ahead, Counsel.
Once again, Your Excellencies, I am Nwankwo Blessing, and I'll be canvassing arguments on the merits of jurisdiction, admissibility, and issues 1 for the next 14 minutes. With respect to our arguments on jurisdiction, it is a tried principle of law that jurisdiction is very sacrosanct as it goes to the very heart, the very root of any matter before the court. According to Rules 49, Sub-Rule 1, as well as Rule 50 of the Rules of the African Court on Human and People's Rights, it provides that the court must always conduct a preliminary examination into its jurisdiction and into the question of admissibility in any case that comes before the court. The jurisdiction of this court, Your Excellencies, is provided in Articles 3 and Articles 5 of the protocol establishing the court. While Article 3 provides for the material jurisdiction of the court, Article 5 provides for the personal jurisdiction of the court. Article 5, Sub-Article 3, especially, Your Excellencies, provides that these courts shall have provides that it grants conditional access to individuals and NGOs who have observer status, Your Excellencies, who have observer status before the African Commission. However, that access is predicated on a requirement which must be fulfilled in Article 34, Sub-Article 6, which provides that the respondent state must have made a declaration accepting the jurisdiction of this court. Applying these rules of the law to our substantive case, it raises two peculiar issues. Firstly, the absence of observer status of the applicant, which is the Challenge and Change Association. And secondly, at the Article 34.6, the absence of the Article 34.6 declaration by the state of Akunda. We proceed immediately to the lack of observer status. It is nowhere mentioned in our statement of fact that the Challenge and Change Association had attained observer status before the African Commission. And indeed, we understand that the facts of our case are silent as to whether or not they have observers. We understand it is nowhere mentioned in our statement of fact that the Challenge and Change Association has observer status or not. However, it is our contention that the Challenge and Change Association does not actually have observer status which grants them the local standards institute case before this court. Resolution 361 of 2016 of the African Union, which provides for the criteria of granting and maintaining access for NGOs who have observer status before the African Commission, provides the requirements as well as the responsibilities which accrue to NGOs that have or that intend to apply for observer status before the African Commission. It provides that such NGOs must have sufficient reach. It provides that they must have the capacity to actually undertake matters of promoting and protecting human rights. However, it is our contention that the Challenge and Change Association did not fulfill this particular criteria of having widespread reach and influence. We predicate our arguments on paragraph 21 of our statement of facts, which refers to the Challenge and Change Association as a local NGO, Your Excellencies, a local NGO. There are a total of 3 NGOs, which are 3 non-governmental organizations, which are mentioned in our statement of facts. The first one can be found in paragraph 17, which is the Freedom Initiative. It is expressly stated that this is an international NGO. The second NGO, which is provided, can be found in paragraph 18 of our statement of facts, Data GIX International, which again is an international NGO. Your Excellencies, according to the rule of interpretation known as nocito est sis, any legal or judicial provisions must be interpreted in the context in which they appear. The experts mention that they are international NGOs and that the Challenge and Change Association is a local NGO, shows that the Challenge and Change Association is a localized NGO without the sufficient spread and reach of other NGOs. And it is our contention that this lack of widespread reach and sufficient capacity is an indication of the fact that they do not have observer status before the African Commission.
Counsel, what evidence does support the observer status of an NGO in the African human rights system? What evidence do you need to determine whether an NGO has observer status or not?
Resolution 361 of 2016 of the African Union provides for the name of the title of that resolution is Criteria for Granting and Maintaining NGO Status Before the African Commission.
So you are pleading the silence of the law, basically. Do you believe you need to demonstrate otherwise that this NGO meets the criteria? Okay, do you have the fact? You have the fact and you are pleading the silence of the law. If you are pleading the silence of the law, you plead the silence positive or negative. Because the other party, you have heard their pleadings. They are basically saying they're pleading left. And you are saying you're pleading right. So the only thing you might want to do is to support your argument on why you want to plead right. That is the silence of the law means that that rule must be observed. If it is negative, it means the silence of law means that the rule need not be observed. So what are you saying? Are you saying that because it is not provided for in the fact, therefore we shouldn't consider that the observer status is there? And if you are pleading so, how are you pleading negative silence of the law?
Most grateful, Your Excellencies. What we are pleading actually is that the facts of our case are not silent on the matter. A logical following of the facts of our case, as I have explained, shows that the Challenge and Change Association, CACA, does not meet the requirement of widespread reach and sufficient capacity to meet sufficient capacity, as provided that these are requirements that must be had by NGOs who possess.
No, the issue is that you as counsel, you can't determine whether that NGO meets the criteria or not. Okay? You do have the fact and then you stick to the fact. The facts are to the effect that nowhere it is stated whether this NGO has observer status or not. Okay? Now, if you are saying you plead the silence of the fact, you are basically saying because the facts are silent on this, yes, okay, it means it is not there. They are saying, the other party, the applicants are saying, because the facts are silent on this, it means it is so obvious that it should be there. So I'm now asking you, do you need to go the whole way trying to have the NGO meet the criteria in the resolution?
Most grateful, Your Excellencies. We indeed plead the silence of the law on the negative aspect, which is that the NGO does not possess observer status before the court. Most grateful, Your Excellencies. We proceed immediately to the second issue, which borders on our jurisdiction, which is the absence of the Article 34.6 declaration by the state of Akunda. This is very clear reading of paragraph 6 of our statement of fact, that while Akunda had ratified the protocol establishing the court, it had not made a declaration under Article 34.6. Your Excellencies, it is an established position of this law, supported by a plethora of cases, including Femi Falana and the African Union, as well as Michel Yogogombaye and Senegal, that the absence of a 34.6 declaration simply means that this court is not seized with jurisdiction to entertain the matter against any state which has been sued by the NGOs or the individuals, according to Article 5, Sub-Article 3. We have listened to the arguments of the respondents on the basis that this court should assume this jurisdiction by virtue of the international law principle known as forum prerogatum. Your Excellencies, this principle of forum prerogatum was first propounded in the Corfu Channel case between the United Kingdom and the Republic of Albania, where it was decided that the fundamental principle guiding jurisdiction of all international courts and tribunals is consent by the state, Your Excellencies. Consent by the state. It is a condition sine qua non, a very, very fundamental condition which must be fulfilled before any international court or tribunal can assume jurisdiction over any matter. We anticipate.
Counsel, are you before the court?
Indeed, Your Excellencies, we are before the court.
Okay. Did you file pleadings?
Yes, Your Excellencies, we filed pleadings before the court.
So you are before the court, you filed pleadings. So now, are you saying you filed pleadings, so you responded to the applicant submissions? You are before this court, you are pleading before the court, and you are telling the court you don't recognize the jurisdiction of the court. Now, this is a bit difficult, because now you are also asking the court to take some actions, to make some orders. You are making prayers to the court, yet you are telling the court you do not recognize the jurisdiction of the court merely because you did not bring in consent. Now, how do you locate consent in international law and in respect of recognizing the jurisdiction of courts? Do you locate consent pre, during, or post case? And you are raising the Corfu Channel case. Meanwhile, you are very much aware that when you compare Article 24.6 of the court protocol to the regulations of the ICJ, statute of the ICJ, and rules of the ICJ, they cannot be amalgamated, they cannot be compared. Because before the ICJ, you do have overall jurisdiction, and then you do have case-by-case jurisdiction. How do you amalgamate these two regulations in terms of jurisdiction, basically. So you have an application, you respond to the application, you stand before the court, you're arguing before the court, you're making prayers to the court, yet you are saying you have not consented to the jurisdiction of the court.
Most grateful, Your Excellencies. We wish to, in reply to this question, bring to the notice of the court the facts of the case, of the Corfu Channel case. In that case, there was a dispute as to the there's a dispute brought by the United Kingdom as to the destruction of some of its vessels in the Corfu Channel in Albania. Your Excellencies, in that case, the Albanian government was saying that it did not have, that the court did not have jurisdiction in that case. However, they had filed their pleadings. So in a judgment given by Judge Daxner in that case, the judge held that the actions of Albania in coming before this court and filing pleadings did not amount to an acceptance of the court's jurisdiction, stricto sensu, but rather the appearance before this court was for the reason and purpose of challenging the jurisdiction of this court. We contend that this applies to us in this case. The reason for our appearance before this court is to challenge the jurisdiction of this court, Your Excellencies.
Good and fine. Now, in the Corfu Channel case, the issue is what was the outcome of the case, by the way? What was the outcome of the case?
Eventually, Your Excellency.
Was the case dismissed? Okay. In any case, are you going to make prayers on post-jurisdiction before this court? If you are saying you came to challenge the jurisdiction of the court, will you make prayers on merit?
Most grateful, Your Excellencies. We have indeed filed our issues. We have indeed filed some of our issues on merit. However, this is because we are aware of, we hope in the event that this court holds that it does not, that it does indeed have jurisdiction, the state of Akunda is prepared to make an agreement recognizing the jurisdiction of this court only for the purposes of this case, because we are a state that is devoted and committed to protecting the human rights of our citizens if the court does hold that it has jurisdiction. Most grateful, Your Excellencies. This concludes our argument on jurisdiction. We proceed immediately to our arguments on admissibility. According to Article 6 of the protocol establishing the court, as well as there are 7 admissibility requirements which must be fulfilled before any cases are judged admissible before the African court. These 7 requirements are provided for in Article 56 of the African Charter. They also make an appearance in Rule 50 of the Rules of Court, establishing the rules of the African Court on Human and People's Rights. We humbly submit immediately that this case does not meet the particular, we wish to bring to the attention of this court that admissibility requirements are cumulative. The absence of any single one of them is enough to render an entire case inadmissible before this court. This has received judicial backing in the case of Dexter Eddie Johnson and the Republic of Ghana, as well as Frank David Omari and Tanzania. We then move to argue that the admissibility requirement of exhaustion of local remedies has not been fulfilled in this instant case. According to the African court itself, in the case of Peter Joseph Chacha and Tanzania, he held that exhaustion of local remedies under international law is not a matter of choice. It is a fundamental legal requirement which must be fulfilled. However, Your Excellencies, paragraph 22 of our statement of fact lets us know that the applicants in this case have instituted this action before this court without appealing to the Supreme Court of Akunda, Your Excellencies. They claim that the Supreme Court was unwilling to render a decision. Counsel sees that her time is up and seeks for an extension seeks for a grant of extension by the court to round up my arguments on admissibility and the first substantive issue for determination. Most grateful, Your Excellencies. The applicants have claimed relying on the case of Jawara and Gambia that the local remedies in this instant case were unavailable, ineffective, and insufficient, and ineffective. We proceed immediately to their arguments on unavailability. The Supreme Court of Akunda, Your Excellencies, was very much available to be applied to. According to paragraph 7 of our statement of facts, it provides that appeals from the Constitutional Court would lie to the Supreme Court by leave of the Constitutional Court. In the case of Kenya, Human Rights Commission and Kenya, it was mentioned that applicants must show evidence that they have at least tried to obtain relief or remedy from the local source before claiming unavailability. However, Your Excellencies, it's not anywhere stated that the applicant at least applied to the Constitutional Court for leave of the court to apply to the Supreme Court. They immediately assumed by themselves that the Supreme Court would be unavailable because of the elections, which, Your Excellencies, might we add, is still 3 months away. Your Excellencies, the paragraphs 5...
Counsel, would you please enlighten the court? Do individuals have access to the Constitutional Court in your domestic legal system?
Most grateful, Your Excellencies. Individuals have access to the court. Individuals have access to the Constitutional Court in the Republic of Akunda, Your Excellencies. However, the subject of the application must be a matter concerning the interpretation of the Constitution, Your Excellencies.
Yes, now, okay, good. I think you've made your point on admissibility, exhaustion of local remedies, correct? And the applicable law in this respect is 56 of the Charter and 50 of the Rules of Court. Now, you are basically arguing that remedies were not exhausted here because the matter wasn't taken to the Supreme Court of Appeal. Now, I guess you are aware that by provisions of Article 56 of the Charter, for a case to be brought before this court, remedies must have been exhausted only if they exist, 1, and 2, unless their process has unduly prolonged. Now, in this particular case, by the fact, a matter has been pending in court for 3 years. Do you believe, as a respondent state, that 3 years to process a case involving women's rights is a reasonable time?
Most grateful, Your Excellencies. The matter in this case was instituted before the Constitutional Court around May 2022. Your Excellency, in less than 2 months, by July 2022, the Constitutional Court had already rendered a decision in that case. Your Excellencies, this goes to show that under the legal system of Akunda, there is no record of prolongation of decisions. There's no record of unduly prolonged court cases. As such, it's a submission.
I'm referring to part of the fact stating that 11 petitions were filed and that none of those cases had been resolved and that those cases have been pending for 3 years. So I'm not referring to the processes before the Constitutional Court. I'm referring to those 11 petitions in very specific cases which were filed before domestic court and which have never been resolved. And the time that they've been pending there is 3 years. So I'm asking you basically to argue on that. Do you believe 3 years is a reasonable time? Do you believe that is time for the applicant to still be waiting before filing? Don't you believe those 3 years warrant an exemption to the rule of exhaustion of local remedies?
Most grateful, Your Excellencies. We believe that the issue of violence which has been occurring within this period of 3 years was not in any way overlooked by the state of Akunda. Within this period of 3 years, the government had undertaken several executive, legislative measures towards curbing the violation of these rights which were occurring in the state. And it is not our argument that these cases have been pending for 3 years and that they have been ignored by the court. Instead, we contend that the government was doing all it could in the period to alleviate the issues that were giving rise to these cases. The government was doing all it could within these measures to make sure that the root causes of these cases were being tackled effectively, Your Excellencies. This concludes our arguments on admissibility. We submit that the remedies were available in the body of the Supreme Court, as well as the Gender Equality Commission, which was conducting an investigation into this matter. Secondly, we submit that these remedies were also sufficient. The Supreme Court is the apex court of the land. As such, it has the power to grant sufficient remedies, whether in the form of injunctions or award of damages or any other remedies. And also, we submit that the remedies in this case were also effective. We conclude on our arguments on admissibility, and we proceed immediately to the substantive matter for determination. The first issue borders on whether or not there has been failure by the state to effectively prosecute cases of sexual violence as well as online-based gender violence. To this question, we respond that there has been no failure by the state to prosecute these matters of sexual violence as well as online-based gender violence. Your Excellencies, Article 3, Sub-Article 4 of the Maputo Protocol especially requires states to take appropriate measures to protect the right to dignity of women and protection from all forms of violence, including sexual or verbal violence. This obligation of the protocol places a requirement of due diligence on the state. Due diligence, Your Excellencies, was espoused in the Inter-American Court case of Velasquez Rodriguez and Honduras. It connotes the obligation of a state to prevent, investigate, and punish violations of individual rights and freedoms. However, Your Excellencies, you'd agree with me that before a state can punish violations of rights, it first has to conduct investigations into what occurred, how it occurred, what the extent of liability is, who can be held accountable, how they can be held accountable, and how the interest of justice can be fulfilled to both the accused persons as well as the general public, general citizenry of Akunda. Applying this to the facts of our case, Your Excellencies, this is our humble
Counsel, I think you have exhausted your time. Yeah, you have exhausted your time. So,
most grateful, Your Excellencies.
Can you give a chance to your co-counsel to take us through the substantial issues?
Most grateful, Your Excellencies. Okay. We also submit on our substantive issues that there has been no violation by the state to effectively prosecute the matters of sexual violence. If I shall be of no further use to this court, I wish to defer proceedings to my learned friend and co-agent, Akinyemi Akinwumi. Most grateful, Your Excellencies.
Be reminded how many minutes, extra minutes, we gave to the first team. I hope you are keeping track, because we would have to give the same extra time to this team.
Respectfully, Your Excellencies, as earlier introduced, I am Akinyemi Akinwumi, and I shall be addressing this court with respect to the substantive issue 2, issue 3, and issue 4 before this court. Your Excellencies, the state of Akunda is a state which is a firm believer in the rights of women. In this regard, it has made several legislative measures, it has ratified several treaties, and it has also taken several executive steps towards ensuring that the rights of women and girls throughout the state of Akunda is protected. In this right, Your Excellencies, I shall argue first on the second issue for determination as to whether or not the state of Akunda, whether there was failure to provide effective mechanisms to ensure the participation of women in politics. To this question, Your Excellencies, the respondent responds in the negative. It is in fact our contention that the state of Akunda is a firm protector of the right of women to participate in politics. To this effect, it has ratified Article 7 on the Convention of the Elimination of All Forms of Discrimination Against Women. It has ratified Article 9 of the Maputo Protocol, eliminating all forms of discrimination against women with respect to participation in politics. It has also ratified Article 13 of the African Charter. Your Excellencies, the state of Akunda is also aware of the decision of the court in the case of Castaneda versus Mexico, where the court held that the right to political participation must be enjoyed by all without discrimination. And it's in this sense, and in also the fulfillment of its responsibilities provided under the above listed charter, that it ratified its constitution, and then this constitution is one that sought to eliminate all forms of discrimination against women. Your Excellencies, apart from taking these legislative steps, the state of Akunda has also taken active steps towards ensuring effective participation of women in politics. First off, Your Excellencies, the state of Akunda provides for an Electoral and Parties Act, which provides for not only mandatory quotas, Your Excellencies, but also voluntary quotas, which must be compulsorily filled by women in political parties in the state of Akunda. Not stopping at this, Your Excellencies, the state of Akunda also has 11 female governors, Your Excellencies, and a female vice president. This is a state that indeed ensures the effective participation of women in politics. To put this into perspective, Your Excellencies, when the Republic of Kenya in the year 2021 had 7 female governors, the entire international community praised it as a state which recognizes the rights of women to participate in politics. In comparison, Your Excellencies, the state of Akunda has 11 female governors and a female vice president, Your Excellencies. We contend that the state of Akunda is indeed a state that provides for effective participation of women in politics. Your Excellencies, it is also our contention that the respondent is aware of the fact that the state not only have to promote the right, but also has to protect the right. In this wise, it has established the Gender Equality Commission, which is responsible for investigating matters militating against the participation of women in politics. The Gender Equality Commission has taken its work to heart and is investigating matters of people who has militated against the right of women to participate in politics, and for sure would ensure that these individuals are punished in light with the national laws which the state of Akunda has, as well as international treaties which it has ratified.
Council, do you
Yes,
believe the quota policy would be a panacea in a place like Africa, where you do have a number of other factors and parameters that come into play when quota is implemented? So now, are you saying basically because you are applying certain quota policies, you are resolving the issue of women's rights protection, strictly speaking, or as provided for in treaties? Because now here, number one, there are some levels of quota required. Does the state meet these quotas as prescribed by regional standard? That's number one. And number two, do you believe quota is properly applied when some others of the pillars that will give full effect to quota are not met fully? Here is a state that does not meet some of the basic requirements of economic and social right as de facto state. And therefore, you are saying you want to build concrete on top of what is not concrete. So do you believe that going a top-down approach to quota without having social or societal other measures to support that kind of policy, do you believe it is an end in itself to have to apply a quota policy?
Most grateful, Your Excellencies. Our argument is not that only the quota measure was a measure which was put in place by the Akunda government. The quota measure is one of the measures which was put in place to ensure effective participation of women in politics. Apart from that, Your Excellencies, we shall also argue further, while we are arguing our remaining substantive issues, that the state of Akunda has tried all within its best, within the maximum of its financial resources, to take care of both the economic and social rights of the state of women and girls in the state of Akunda, notwithstanding the fact that it is a poor state. Your Excellencies, the state of Akunda has put in quota measures. It has also put in several other measures. For example, the Gender Equality Commission, whose only task is to ensure that it investigates into violation of the rights of women. So it has put in different measures, ratifying treaties, quota measures, and also investigation and prosecution of individuals who actually violate the rights of women, Your Excellencies.
Council, now who are the members and how are they appointed? Just to understand.
Most grateful, Your Excellencies. So this is what the state of Akunda does. It provides for mandatory quotas which must be filled in any political party to be registered in the state of Akunda. So if you are to register a party, say NNPP or State of Akunda Party, you must make sure that your political party has or is filled or is made up of a required number of women, to make sure that women's right to political participation is indeed enforced and is recognized in the state of Akunda. So you can't have a political party in the state of Akunda where there are no women or where women are discriminated against. Why? Because the law has enforced and made it mandatory that women must actively participate in politics through the quotas that are provided, Your Excellency.
Council, if I may, Mr. President, if I could add to the question by my colleague, Excellency. Now, when it comes to digital rights and the use of digital platforms to campaign and run for electoral positions within the state of Akunda, could you clarify on the allegations brought forth by the applicants on how the intersectionality between freedom and protection of digital rights as a critical platform for achieving gender equality in politics?
Most grateful, Your Excellencies, for that question. Your Excellencies, we recognize, the state of Akunda recognizes digital rights and the right of women to access the internet. In fact, this is provided for in Article 9 of the African Charter ratified by it, Article 10 of the Akundan Bill of Rights, as well as Article 19, 2A to C of the International Covenant on Civil and Political Rights. Your Excellencies, however, these rights come with so many duties, and as such, they can be limited in certain instances, Your Excellencies, and I shall further elaborate on this. These rights can be limited when they are provided in law, first. Second, Your Excellencies, when these rights are necessary to pursue a legitimate aim, such as the protection of the rights of others, the ensuring of national security within a state, and also the prevention of leak of information. And thirdly, Your Excellencies, these rights can be limited in instances where the limitation of the right is proportionate, that is, where lesser restrictive measures are used. Your Excellencies, with respect to the first point.
Council.
Yes, Your Excellencies.
I had a question also on the Gender Commission, Gender Equality Commission. You, in your oral pleadings, you just said that the commission can investigate and prosecute.
Yes.
So, do you want us to understand that the commission is also a kind of judicial remedy of judicial nature?
Your Excellencies, the commission can investigate and recommend prosecution of individuals who violate these rights. Yes, most grateful, Your Excellencies. With respect to the question asked by Your Excellency to digital rights, so Your Excellencies, we contend that the limitation of these rights were actually provided for in law, as can be seen from the statement of agreed fact, where the Communication Authority, which shuts down the internet, relied on the provisions of the Communication Act embedded in the Akundan law in carrying out its actions. This is to ensure that the act was not done arbitrarily, but it was done in line with the process of the law, Your Excellencies. We also contend that this limitation was necessary in order to pursue legitimate aims in the Republic of Akunda. Your Excellencies, we contend that, as can be seen from the usage of the internet, several individuals had when the Order XVII was promulgated, a lot of protests arose from the promulgation of the Order XVII, and this led to a lot of protests within that spanned throughout the Republic of Akunda in that stand case. Your Excellencies, we contend that such protests were threats to national security, and it was imperative for the Akundan government in that instance to temporarily, for a little period of time, Your Excellencies, temporarily shut down the internet just to ensure that peace is restored to the Republic of Akunda. Yes, Your Excellency.
Okay, there's a difference between absolute and partial, and a difference between timely and indefinitely. Okay? So now, here, you are saying the internet shutdown was just temporary, but it was total. So you shut it down completely, just for a few days. Do you believe harm can be done by having a total shut of the internet for a few days versus half shutdown of the internet for a longer time? Now, we do agree with you that as per law, including international law, rights are not of absolute enjoyment. They can be restricted, but now there are conditions to the restriction. And one of the conditions is proportionality. When you put those two elements in the balancing right mechanism, you have on the one side women's right to political participation, etc., etc. Okay, you know the importance of women's protection, women's right protection in building stable and strong societies. On the one side, but the other side, you have the issue of national security, which you could have addressed by regulating the use of internet instead of shutting down internet completely. So don't you believe there were lesser restrictions to meet the same result?
Most grateful, Your Excellencies, for that question.
Council,
Yes, Your
after you've
Excellency.
answered that,
Yes, Your Excellency.
I think you are aware that Ankunda is a patriarchal society, and I want to know the extent to which the state applied mechanisms with a gender lens, even as the state was talking about the shutdown. To what extent was gender mainstreamed in the processes which culminated into the shutdown?
Your Excellencies, please, if you could repeat that question so I could understand it better, Your Excellency.
You're aware that the Ankunda state is patriarchal.
Yes, Your
You're
Excellency.
certainly aware that women's lived realities are different from the lived realities of men. And indeed, we realize now that perhaps women were more affected than the men. And the question for me to you is, to what extent did the state apply mechanisms to cushion the vulnerable members, such as women, vulnerable members of the community? Did the state at any time put on a gender lens to see the extent to which women were likely to be more affected than the men by the order which culminated into a shutdown?
Most grateful, Your Excellencies, for that question. I shall address the first question first, Your Excellency, and then the second question. Your Excellencies, with respect to your question, we contend that the Republic of Akanda did not just arrive at the total shutdown of the internet, as it tried to first regulate the internet, and it first tried to promulgate an order and ask law enforcement agencies to regulate the internet. This has can be seen in paragraph 22 of the Statement of Agreed Fact, where Order XVIV was passed by the government. This order was meant to regulate the internet. Also, the Vice President in her speech stated that Order XVIB has been gazetted, and it creates an offense of cyber harassment, Your Excellencies, against anyone who uses digital platform for apprehension against another person. This is a prosecutable offense, and our law enforcement officials shall be monitoring social media platforms, Your Excellencies. A clear attempt at regulating the internet first. That was the first step of the government. Your Excellencies, it was after the promulgation of this order led to a protest, a nationwide protest in the Republic of Akanda, that the Republic of Akanda was first to approach other means towards ensuring that national security was provided back in the Republic of Akanda. And with respect to, Your Excellencies?
Do you understand what it means to ban a political party from running for elections?
To ban
and
a
more
political
so,
party?
And more so, yeah, because basically here the facts are to the effect that a particular political party was prevented from participating fully in the election. Because the internet was shut down, and that was their main means of running their political business. So basically here we reached the result of that party not being able to participate fully in the election, the leader of the party having to be on the run, because there were allegations of breach of security, national security against that person. And now here you are saying the only measure that you could have come about to solve this issue, resolve this issue, was to bring down the internet completely, totally. So do you measure this against the claim of national security, the fact of having to ban or prevent an opposition political party from participating in the election, and more so a woman-led political party whose members and audience was largely women-based.
Most grateful, Your Excellencies, for that question. Your Excellencies, the Republic of Akandan, in this instant case, actually tried to regulate the internet first. And then the space between the temporary ban of the internet to the period of the elections was a wide space of 3 months, Your Excellencies, and the internet was only temporarily banned. And that would mean that members of the Women Gender Political Party, after the temporary ban of the internet, will still have time to canvass for political support using the same means of internet after the ban was lifted, as the space was a space of 3 months, Your Excellencies, before the election started. Most grateful, Your Excellencies. Your Excellencies, we also contend that the Republic of Akanda, Your Excellencies, Council time is up and 6 extension of time to round up the issues, Your Excellency.
You have 2 minutes.
Most grateful, Your Excellencies. Your Excellencies, the state of Akanda took measures such as calling on stakeholders in the state to ensure that they revise their end-to-end description methods so that women in the Republic of Akanda can be protected and people militating against these rights can be fished out and punished according to the national legislation in the state of Akanda, thus ensuring that women's rights are indeed protected in the state of Akanda. To the last issue for determination, Your Excellencies, we contend that as to whether or not the Republic of Akanda has provided for socio-economic rights. Your Excellencies, socio-economic rights have also been provided and ratified by the state of Akanda in Article 10 of the Convention on Elimination of All Forms of Discrimination, as well as Article 12 of the Maputo Protocol with respect to the right to education, and on the right to water, Article 14 sub 2H of the Convention on All Forms of Elimination, and Article 15 of the Maputo Protocol. However, Your Excellencies, a brief look at Article 2 sub 1 of the ICCPR will show that states are only mandated to do this to the maximum of their financial resources. Your Excellencies, the state of Akunda is actually a state which is trying to ensure that the socio-economic rights of individuals in this state are protected to the maximum of these financial resources, notwithstanding that the state is poor as provided for in paragraph 2 of the Statement of Agreed Facts, a state which has less than $700 per capita GDP. Your Excellencies, we thus submit that the state of Akunda has tried all within its means to provide for the socio-economic rights of women and girls in the Republic of Akunda. Your Excellencies, we submit before this court and pray to this court to hold that the Republic of Akunda has not violated the rights of women and girls in Akunda. Your Excellencies, we contend and we prove to this court that the state of Akunda is a poor state which is trying all within its national resources, and also that it has taken legislative measures, executive measures to protect the right of these women, and we urge the court to hold in our favor in this instant case, Your Excellencies. It has been an honor arguing before this temple of justice.
So,
yes, Your
the
Excellency.
President has allowed me to ask a question. You have said that the state of Ankunda has done what it ought to do because what is required of a state is to use the maximum that they can as a poor state. Are you aware of the fact that ICES is whatever?
Yes, sir.
Yeah, actually obliges states to take steps individually and through international assistance and cooperation.
Yes, Your Excellency, we are aware of that fact, that states are also expected to take such measures, Your Excellencies. And in this regard, we actually wish to point the attention of the court to the fact that Akunda is taking all of these steps to progressively realize the rights of women in the state of Akunda. Your Excellency, in paragraph 17 of the Statement of Agreed Fact, it provides that the president of Akunda promised women and girls in the Akunda region access to an advanced irrigation system. Your Excellencies.
Yes, yeah, Council, I think what was important was to disabuse us of the statement that all you need is to do what you can from your own resources, because indeed you are obliged to go beyond that and bring on board international assistance and cooperation.
Most grateful, Your Excellencies. We also wish to urge this court to take into consideration the circumstances in which this fact of the case occurred. Your Excellencies, it occurred during a period of COVID-19 pandemic where all states were within the threshold of their financial resources. Your Excellencies, so it would not be really possible for the state of Akunda to seek for resources from other nations. Most grateful, Your Excellencies.
Thank you very much, Current Counsel. Now I understand the applicant had reserved 3 minutes for rebuttal. You take the floor.
Most indebted, Mr. President, if the court is pleased, I will make our rebuttals for the applicant's case. Firstly, the respondent submitted that jurisdiction is sacrosanct, but it is our respectful submission that Rule 29 sub Rule 3 of the African Court Rules of 2020 provides discretion upon this court in the exercise of its jurisdiction. Rules are meant for the court and not the court for the rules, and therefore the court cannot be bound by this idea of sacrosanctity as submitted by the respondents. The respondents also submitted or also proffered the idea that because Challenge and Change Association is asserted as a local non-governmental organization, it implies that they do not have observer status. But it is our respectful submission that an organization can be a local organization but still have observer status from the African Commission. And we refer to the case of Malawi African Association and others versus Mauritania, whereby the organization was a local organization within Malawi, but it had observer status from the African Commission, and it was still allowed to approach this court for redress. The respondent also submitted that, also referred to the case of Yogogomboye versus Senegal on the basis that the court should not exercise its temporal jurisdiction. But it is our respectful submission that what the respondent submitted is misleading in that particular case. The court in the case of Yogogomboye versus Senegal, application number 1 of 2008, actually entertained an application which had been brought against Senegal, which had not deposited the declaration pursuant to Article 34, sub-Article 6 of the African Court Protocol, confirming this court's jurisdiction. The applicants also, the respondents rather, also submitted that within the 3 years, the government was doing all it could, and this is provided for in paragraph 20 of the facts. But it is our respectful submission that from paragraph 20, there is no evidence of the government doing anything. What the government did is provided for in paragraph 21 of the facts. What they actually did was for the Constitutional Court to assert that the courts within Akunda have no jurisdiction to adjudicate over violations emanating from online gender-based violence. That is what the government of Akunda did within that period. The respondents also submitted in respect to the merits that they should be exonerated from blame arising from the applicant's case on the basis that Akunda has a number of treaties, they have ratified conventions, and that they have Political Parties Act which provides for the rights of women. It is our respectful submission that women and girls, the vulnerable women and girls in Akunda, who are being continuously sexually abused and politically excluded, cannot benefit from rights on paper. They should benefit from actually the practical implementation of these rights. And the fact shows that the state of Akunda has failed in that regard to ensure that there is effective implementation of these rights which are on paper. They also submitted that there are 11 women governors out of 55 prefectures. And that shows that they are doing enough as far as the guarantee of women's rights is concerned. And those will be our submissions for the applicants.
Thank you very much. Respondent.
Most grateful, Your Excellencies. We'll proceed immediately to share rebuttals to the applicant's arguments.
For the registrar, you have 4 minutes. You reserve 4 minutes for rebuttal.
Most grateful, Your Excellencies. The applicants have argued that the Constitutional Court, that by virtue of the fact that Constitutional Court held that it does not have jurisdiction, and because the Supreme Court is similarly unwilling to render any judgment on this matter because of the upcoming elections, that local remedies within the state of Akunda were completely unavailable. However, Your Excellencies, a brief perusal of paragraph 7 of our statement of facts lets us know, introduces us to the Akundan legal system and tells us that there were magistrate courts, there were high courts, several other courts existing within the Akundan legal system. As such, if the Constitutional and Supreme Court were unavailable, they could have also taken their case to either the magistrate court or the high court. In addition, the Gender Equality Commission, by virtue of the fact that it is empowered to conduct investigations and recommend prosecutions, is in a way a quasi-judicial body. As such, it was also available for the applicants to take their submissions to. Secondly, we wish to bring to the applicants have claimed. Secondly, in the case of Kenya Human Rights Commission and Kenya, it was held that it must be shown that the applicants have at least tried to obtain remedy from the said local remedy before claiming unavailability. However, the applicant, paragraph 7 of our statement of facts lets us know that the Constitutional Court can grant leave to apply to the Supreme Court. However, the applicants in this instance case have not shown any evidence to this court of their application seeking the leave of the Constitutional Court to apply further. The applicants have also claimed that the Supreme Court is unwilling to give a decision on this matter by virtue of the fact that elections are near and elections are in 3 months. However, Your Excellencies, we wish to point out that according to paragraph 22 of our statement of fact, the applicant's matter before the Constitutional Court was decided in less than 2 months, Your Excellencies, in about 2 months. As such, them claiming that a space of 3 months would not be enough for the Supreme Court to render a decision by virtue of upcoming elections does not hold any water. Akunda is a state that is known for delivering quick decisions, and which even the applicants themselves have benefited from. They have also argued that the rights of women to be protected from online and gender-based violence, which is provided for by the Akundan state, is merely a right that exists on paper, a right that was not in any way enforced and championed by the state of Akunda. However, Your Excellencies, this is not true. This is not the correct position of our statement of facts. In addition to the legislative measures, which include Order XXIV, the amendment of the Constitution to specifically include a clause for the promotion of women, as well as the Election and Parties Act. In addition to these legislative measures, the state of Akunda has also taken several executive measures to make sure that these rights are realized and are not just on paper. Some of these measures include the actions of the government, which can be seen in paragraph 9 of our statement of facts, where they took steps to make sure that women within the state of Akunda were educated. Our statement of fact lets us know that the government provided laptops and internet connection to all the citizens so that they could educate themselves about their rights and their obligations as citizens of the country. Secondly, the government also, our statement of facts also records in paragraph 11 that the school retention rate of women, by virtue of the actions of the government, increased from 56% to over 80% in a single year. Also, according to paragraph 15, it lets us know that the government allowed the registration of the Women Gender Party and also upheld the women's rights to have their own political party when several cries and calls came for the Women Gender Party to be deregistered. The government refused to heed any of those calls, but upheld the women's rights to own their own party. Again, Your Excellencies, in paragraph 10 of our statement of fact, it shows us that the President Jakusha Juma, provided that in response to the plight of the women in the Medu region, that there was going to be a launching of an advanced irrigation systems. Your Excellency, in light of all these executive measures of the government, it cannot be claimed that the rights merely existed on paper. The applicants have also argued that there's been a pattern of violations which governments have failed, a pattern of violations of socioeconomic rights which governments have failed to take heed to, and that this pattern has begun since 2020. However, we wish to point the court to the fact that in the same year, 2020, this will be the conclusion of our share rebuttals on this issue. Most grateful, Your Excellencies.
Thank you very much, Lead Counsel. Now, the court has heard the arguments from both parties. And of course, the matter will be taken to deliberation, and the date for the delivery of the judgment will be communicated to the both to the parties, the press, and also the public. Now it's my duty to declare the session adjourned for now. Thank you very much.
All rise. Veuillez vous lever. Please be seated. Veuillez vous l'asseoir.
Good afternoon, everyone.